Permission to proceed?
Yeah.
May it please the court, opposing counsel, members of the jury. Today's case is about separating the emotion from the evidence, sifting our feelings from the fact. You see, the death of Vanessa Sullivan is a tragedy. And if we had to decide whether or not losing a member of our community was sad, upsetting, or tragic, that choice would be easy. But that's not what we have to decide today. We have to decide whether or not Danny Dawson, a regular 22-year-old college student with the hope of the rest of her life ahead of her, is a murderer. We have to prove that because the state today has decided to overcharge Danny. In today's case, they hold the burden to prove beyond a reasonable doubt that Danny is guilty for every element of the charge they brought. They must prove that Danny acted with deliberate recklessness to cause extreme indifference to Vanessa, Taylor, and her own life. And as we review the facts in today's case, they have failed to meet that burden. You see, on the night of September 24th, Danny, Vanessa, and Taylor were out celebrating Vanessa's 21st birthday. We all heard that they had drinks that night. Danny was unaware she was going to be the designated driver until 12. And when she realized that, she took responsibility, switched from drinking alcohol to sodas to attempt to get her friends home on time. One of the things that she learned at last minute was this curfew Vanessa had, that she had to be home at 1 in the morning, and they had left Chuggy's at 12:45. As Danny got in the car with her friends, she didn't coerce or force them to ride with her. In fact, we heard from Ms. Hobson today that she directed and suggested to Danny to take Canyon Road, a back road, a shortcut, because they all just wanted to get Vanessa home on time. You see, Danny was speeding that night, but not out of reckless intent to endanger her friends, but merely to try to get them home on time. And that's when factors out of her control occurred. We heard from Taylor and Danny that as she was driving down Canyon Road, it began pouring rain. And it was pouring rain. The state would like us to believe that Danny swerved left and right. But the truth is, we heard from Leslie Roman, as well as Miss Dawson, that as she was traveling that night down the road, an evasive maneuver occurred. She swerved to the right in order to avoid an object, and because of the lack of guardrails, she began sliding in the grass. In an attempt to swerve back on the road, she lost control of the car because of the rain that night. Because of the lack of the guardrails on this side of the road, Danny unfortunately hit a utility pole and a tree. We heard from Dr. Roman that if guardrails had existed that night, if this road was safe, then Vanessa would still be with us today. Now, the state has tried to say that if Danny was intoxicated that night, that she's a murderer. Yet the evidence that they've attempted to bring fails to prove that. Let's talk about these field sobriety tests that the state says proves that Danny was intoxicated. Immediately after the car accident, Danny was offered no medical attention and forced to do these field sobriety tests while Vanessa's mother had arrived. Now, like any mother, Miss Sullivan was devastated and grieved by the death of her daughter. But unlike any mother, she's also the district attorney in today's case. And as the DA, she wields an incredible amount of power. And as she started yelling, "I am going to make Danny's life a living hell because I still can," Officer Foster began those tests right away. And after she yelled, "I need more evidence for my murder prosecution," Officer Foster concluded that Danny was intoxicated. But as we heard, the conditions where Danny took those tests, on slick roads with no medical attention, with a screaming DA, on an incline of London Bennett's house, on a place where Officer Foster slipped several times. Now, the state has tried to say that Danny had a 0.19 blood alcohol content from this Intoxilizer 8000. Well, let's talk about the Intoxilizer 8000. Dr. Smith was called earlier to testify that she had administered this test. What she also told us was the importance of a 15-minute observation period in order to ensure accuracy. She said that if this 15-minute observation period did not occur, it could greatly skew the results. Yet in today's case, that 15-minute observation period was not observed. In fact, Dr. Smith sat on the stand and said that Officer Foster told her it occurred, and that's why she only watched Danny for 5 minutes. Yet Officer Foster told us he never told her that. Now, Dr. Smith sat on the stand and lied to us, ladies and gentlemen. The state keeps referring to this 0.19 blood alcohol content, but there's no test results that we've seen today. There's no evidence. All we have is Dr. Smith's word. The same Dr. Smith who lied about the observation period. You heard from Dr. Norton today, too, who's also an expert in pharmacology, that pointed out another flaw of the Intoxilizer 8000. That the lung capacity, the ratio that was used, is an average and was not calibrated for Danny's specific lung ratio. Now you see, in today's case, the state has failed to meet every charge that they have brought, every element that they have brought, to prove that Danny was intoxicated, to prove that Danny was reckless. You see, in today's case, driving while under the influence does not automatically mean murder. The state has to prove far more than that and beyond a reasonable doubt. And as we looked at all the facts, once we separate the emotion from the evidence, they have none. They have nothing that they have brought forth that proves Miss Danny Dawson is guilty. And because of that, because of the extraordinary amount of reasonable doubt that these tests were not flawed, doubt that Danny was intoxicated, doubt about the amount of drinks she drank, doubt on their own expert witness testimony, we must believe that Miss Dawson is not guilty. We must return the only verdict consistent with the evidence. The only verdict the law allows. The only verdict consistent with justice. So find Miss Dawson not guilty.